appointment.
Well, you can see the rest of our presentation on YouTube. We have a YouTube channel where you can see everything.
Oh, that's beautiful. Perfect.
So thank you for coming for the beginning.
Right on. Thank you. I just wanted to see if I could actually get it to work.
All right. Good after Good afternoon, everybody, and thank you so much for joining us today. I'm Lisa Nelson from Texas Legal Services Center, and I am here with Mabel Menifee from Harris Central Appraisal District and Shay Pankowski from the Harris County Tax Office. And we're here today to talk about inherited property. I'm going to discuss how to clear title, and then Mabel and Shay will talk about property tax concerns. So with that being said, I'm going to let Mabel and Shay introduce themselves, and then we can move on to my presentation. Thank you very much.
All right, I guess I'll go next. Good afternoon, everyone. My name is Mabel Menifee. I'm with the Harris Central Appraisal District. I am also joined by my colleague, Lydia Hernandez, who is an exemption specialist in our Information and Assistance Department. She can answer additional questions about if you have any about exemptions as the presentation goes on, or we can take those questions at the end of the presentation. I'm happy to be here to sort of backfill for Lisa when it comes to questions about clearing title, when it comes to property taxes and the exemptions that are often attached to inherited property. So I look forward to speaking with you following Lisa's presentation.
Hi, everyone. Good afternoon. My name is Shay Pankowski. I'm here with the Office of Annette Ramirez with the Harris County Tax Assessor Collector's Office and Voter Registrar. And I'm here to talk about the very last part of property tax billing, which is receiving your bill, how to pay, and things detailing that nature. I'm super excited to be able to come on here and talk to you guys and answer any questions that y'all might have. So, please feel free to ask away, but, keep in mind this is open forum. This is going to be posted online. So if you say anything in regards to your property taxes or issues that you might be having, we do recommend that you keep that, as censored as possible. Don't give away too much of your information because once it's online forever. So just keep that in mind whenever you have any questions. Feel free to put them in the chat and we'll answer them there as well. But I'm super excited to get started with y'all today. Lisa?
Thank you so much, Shay, and thank you for reminding people about that. Please remember that we are live and online and being recorded. So I am very happy to answer legal questions, but you want to keep them as general and generic as possible. We don't want you to put your business out there on the internet. So with that being said, I'm going to start my presentation. I want to start by giving you a quick preview of our website since I'm always bragging about it when I give my presentation. I'm with Texas Legal Service Center, and I work on the program that runs the website Texas Law Help. This is a website that, as I show you the topics, it covers pretty much any Texas civil law issue you might have. And one of the services we have from 10 to 2 Monday through Thursday is legal information and advice where you can speak with a licensed attorney. So when you come onto our website, you'll always want to hit refresh to make sure that it's got the current page. And then we've got this option here where you can chat with an attorney. So thank you very much for all of you who've used our website in the past, and please take advantage of our program. Can everybody see my screen? I'm not sure if I'm in
Yes.
Okay. So my topic today is clearing title and other probate concerns. It's to talk about how to handle inherited property. I when I worked at Earl Carl, I spent a lot of my time helping people get clear title to their family property. And one of the big issues that happens when you're encountering these issues is that you realize that you need to get your property tax exemption straightened out at all. So that's why I asked Mabel and Shay to join me when I give this monthly presentation. So I'm going to give you a quick review of the probate process. For those of you who have attended our other workshops, every month we also have workshops on the importance of estate planning and how to create your own estate plans. I explain what happens when those estate plans are in, basically what happens after someone passes away and how you handle their estate. Then we focus on how to clear title to any family property and what to do to prevent this problem in the future. And then I'll pass it on to Mabel and Shay to talk about property tax issues. I'm with Texas Legal Services Center. We are a statewide nonprofit that provides advice, advocacy, representation, and education to underserved people across the state. We have more than a dozen practice areas that touch almost every aspect of civil law that impacts low-income Texans. Our mission is to ensure equal justice for all Texans. So let's get started with probate concerns. There's a lot of new vocabulary that you need to learn when you have questions about probate. So I spend a few minutes going over that. A decedent is a person who passed away. If the person passed away with a valid will, it's considered a testate estate. An intestate estate is when a person passes away without leaving a will. A testator is the legal term for someone who is signing a will and someone who has a will in place when they pass. And a will is a legal document which states how the testator's property is to be distributed at death. Estate is your stuff. It's both your real and personal property owned by someone at the time that they pass away. And probate is the court process of winding up someone's affairs, whether they have a will or don't have a will. If they have a will, it's considered a probate. If they don't have a will, it is considered administration. There are several terms that all mean personal representative. If a person had a will, an executor is the person who's responsible for wrapping up their affairs and distributing the assets to the beneficiaries. If there was no will, there is someone called an administrator who does the same thing. And the heir or beneficiaries are the names for somebody who inherits through a will or by law. There's a lot of common mistakes that people think about. All the time I hear people thinking that, well, Mama didn't have a will, but I was her power of attorney. Powers of attorney are only valid while a person is living. Once someone passes, the power of attorney is void. A surviving spouse has a life estate in a person's home. I have met so many people that think, well, I'm married, so I own that house just as much. If you marry someone who purchased a home before the marriage, that house can be their separate property. I mean, it's far more complicated and requires some investigation, but don't assume that just because you're married, the house belongs to both of you. If someone marries someone who already had a house, when that person passes away, the surviving spouse has a right to stay in the house for the rest of the life. It's called a life estate. They are responsible for property taxes and maintenance, but they have a right to live there for the rest of their life. After their surviving spouse passes, that property would go to any separate children that were not from the marriage. And it's important when you're writing a will that your executor is over the age of 18 and also lives within the state of Texas. AMS has many, many opportunities for you to get your own will and estate plans for free. We also provide documentation for you to prepare your own plan. It is always best to have an attorney prepare your will. There are ways in Texas that you can make a legally valid will on your own, but I always will recommend to talk to an attorney to make sure everything's done correctly. Forms, a lot of people are worried that an attorney is going to charge them thousands of dollars, so they go to some place like Wills and Trusts or LegalZoom because that's just a few $100s. The problem is forms from those websites may not be valid pursuant to Texas law. They're written to be as general as possible, and Texas law has very specific wording that has to be within the will for it to be valid. The Texas Supreme Court has approved forms for someone to do their own wills. We have those available on our website, texaslawhelp.org. In the past, all the time, I would run across situations where spouses had the same will. One of the spouses would write everything out and they both would sign it. That is not a valid will. Each spouse must have their own will. If you're in an emergency situation, you are allowed in Texas to handwrite your own will. It has to be completely in your own handwriting, and it's called a holographic will. You can find information about it on our website. And most importantly, you need to keep your will in a safe place that your loved ones know about. If they can't find your will, they will not be able to probate it. And Texas law has a very strong preference for the original. If your executor can't find your original will, Texas law presumes that that will has been revoked, that you ripped it up and shredded it, threw it in the trash, whatever. If they can only locate a copy, that means that they're going to have to prove to the judge that you did not intend to revoke your will. If you die without a legally valid will, the law determines who will inherit your property. It will not be who you want. It will be who the law considers your next of kin. And I took the description out of my slideshow because it's very complicated, but I believe in the follow-up email you will get a copy of it. There's detailed Texas law as to who inherits if you pass away without a will. If you can't find a will at all, you can't find a copy, you can't find anything, you can file an application for administration. There are several different procedures depending on the circumstances. In extremely limited cases, you can file a small estate affidavit. Now, for better or for worse, Texas law requires that you have an attorney for any type of probate process. And what you need to do is consult with an attorney to determine the best way to proceed. They will know the most cost-effective and the most most cost-effective and the most effective in terms of your time. If you try to do it this is one of the reasons why Texas law requires an attorney. If you try to probate a will on your own, quite often you will go down the wrong path and spend a lot of money on court fees that you will not get back. I will spend some time later in the presentation to explain why the exact circumstances when you can file a small estate affidavit. Probate assets are property under the testator's name that pass through a will. That could be anything you leave in a will. So it could be your home, and it can be all of your personal property, your home, your furniture, your appliances, your clothing, all of those things you can pass through a will. Texas also has what's called non-probate assets, which do not pass under a will. They pass in accordance with the terms of a contract. So this would be a life insurance policy, retirement plans, and any account with a payable on death beneficiary. The best tip that I can give you from this presentation is that if you have payable on death beneficiaries on all of your financial accounts and a transfer on death deed for your home, your family might not need to go through probate. One of the things I recommend every 5 years or so, look through your banks, look through any kind of financial policies you have, look through insurance policies, check with your agents, and make sure that you have payable on death beneficiaries. Those people will be able to report to that institution with some documentation and inherit that money right away. They will not have to go through the probate court, which can take more than a year. Harris County probate courts are overwhelmed and backed up. So if you have those payable on death beneficiaries and you have a transfer on death deed on your home, your family could be able to wrap up your affairs much sooner and for much less cost. Small estate affidavits are the only probate procedure in Texas that you may not need to have an attorney. There are some counties in Texas that will require you to have an attorney. I believe Liberty is one of those. Harris County at this time does not require you to have an attorney with a small estate affidavit. This leads to a lot of misinformation because if someone passes away and their loved one goes to the courthouse, to the probate office and says, my aunt passed away. She didn't have a will and I don't have a lawyer. What do I do? They'll tell you to do a small estate affidavit. Well, that rarely works. And then you're out about $400 because the judge is not going to sign off on it and you won't get a refund. So small estate affidavits can only be used to transfer real property if you meet the following conditions. You can only use a small estate affidavit to transfer a home if there's a surviving spouse or a child under the age of 18. If you are an adult who's been living with your parent, taking care of that parent, the small estate affidavit will not transfer the house to you. That's unfortunate, but it's what the law is at this time. Also, everyone has to agree to wrapping up the estate this way. So anyone entitled to inherit from the deceased person by law has to sign the small estate affidavit. You also have to have 2 disinterested witnesses. That would be 2 people who knew the deceased person well, but do not legally inherit from that person. You cannot use a small estate affidavit if the deceased person had a will. And you cannot use one if the value of the assets, okay, I'm sorry. You can't use a small estate affidavit if the debts are greater than the assets of the estate. This does not include the homestead. So say you have a home that's worth $350,000. That is not included in the estate assets. Homesteads are exempt. But then the person owned maybe 35,000 of other types of property, their car, their clothing, things like that. But they had $40,000 in credit card debt. The judge will not accept a small estate affidavit unless there is sufficient money in the estate to pay any debts. And finally, the estate, not including the homestead, has to be less than $75,000 in value. If you were able to probate a will, or if you were able to use the independent administration process, what happens is the attorney begins by filing an application. The application has to be on file at the courthouse for 10 days, and then the attorney can schedule the hearing. This does not mean that you will go to court within 10 days of this filing. Harris County, you're looking at least 6 months. You will go in front of a judge for a very brief 5 to 10 minute hearing. The judge will hear from witnesses and determine that the will is legally valid. Once the judge grants the application to probate the will, the executor receives letters testamentary. And then the personal representative gathers all of the estate assets and they have to open a bank account for the estate. Once someone passes away, their bank closes that account within a matter of days. So what the person will need to do is go to that bank with their letters testamentary, and they also will have to have proof that they have a tax ID number for the estate, and then their bank will allow them to open an estate account. They can then transfer the funds from their closed personal bank accounts to that estate account. The attorney then notifies any creditors of the estate. Do not think that your executor is responsible for any of your bills. They absolutely are not. The creditors are paid from the funds of the estate. And executors, you all need to know that the attorney has to notify the creditors, and the creditors file a claim with the court. The law requires very strict proof of the debts before the debt can be determined valid. And then finally, once that has happened, the attorney with the personal representative prepare and file an inventory. That is a statement of everything the deceased person owned as of the day that they passed away. This is the process both if there's a will or if the estate qualifies for independent administration. Independent administration is a process where all of the heirs agree and all of the heirs are over the age of 18. If that's the situation, most likely the judge will allow an independent administration, which means that it acts almost the same way as the probate of will. If the heirs do not agree, or if there's a child under the age of 18, the court will not allow you to have an independent administration. You will have to have a dependent administration, which is incredibly expensive and time consuming because the judge has to approve everything that you do. And now for clearing title to inherited homes. If you live in a family home, you need to make sure that you have clear title. If you don't have clear title, you don't qualify for any type of disaster relief assistance. And you also aren't eligible for property tax exemptions or deferrals if you're not the owner of record. A clear title means that no one else has a financial interest in your property. It also means that there's absolutely no question of ownership and that you can easily trace the ownership history of a property. An example of this, I had a probate case where we were we were probating the estate so that the person's adult children would inherit the house. We found out in the middle of the probate that there was a lien on the house because of a loan that had been taken out. We did not know that there was a cloudy title. A cloudy title is the term when property has not been legally transferred or deeded to the subsequent owner. This usually happens when someone dies without a will or the family doesn't manage the estate. There is a difference between a title and a deed. Title is not a piece of paper. Title is just the legal right that a person owns the property. Deed is the piece of paper that conveys that right. So real estate title isn't a document, it's the strength of your ownership claim. Having clear title means that there will be no unexpected claims on the property. A deed is the document that transfers ownership to the new owner. In all of my cases, when I would get title clear, I would tell my clients, let's please make sure that you're able to pass this on to your family in the event of your passing. The best, easiest, and least expensive way to keep property within your family is to file a transfer on death deed. Also, if you have a legally valid will in Texas, preparing that will transfer property effectively after you pass away. It's really important, like I said before, if you don't have clear title, you can't apply, you will not be accepted for FEMA, you will not be accepted for any state and local disaster recovery assistance. I would get so many new cases after a hurricane or after that horrible winter storm where, people had serious damage to their homes. They applied for relief and then they found out this property is still in your grandmother's name. We're not going to be able to give you aid, and we would have to clean that up. It's also how you're entitled to property tax relief. We will see people who get clear title, but they don't take that final step of applying for their property tax exemptions. The tax offices will find out about that, and you will owe a great deal of back taxes as well as penalties. And if you don't have a clear title, you're not able to get any type of loans at all. That's why the probate process is so important. If you don't know, say you've had property that an ancestor purchased that stayed in the family all this time, that's absolutely wonderful. But if you don't know if when the original homeowner passed away, if there wasn't any probate, then you probably don't have clear title to that property. It's critical to probate your loved one's estate because otherwise you may not have clear title and you're certainly not going to be able to access financial accounts. There's a few different ways to clear title through the courts. The best thing is to handle this within 4 years of the person's passings. If they have died within the last 4 years, you need to probate their will or file an application for administration. If it's been more than 4 years and they had a valid will, you can file an application to probate as a muniment of title. There's also when it's not as straightforward. This is your home, your family's been in a long time, but the ownership history is not as straightforward. If you meet the requirements, you can file for adverse possession. So as I discussed briefly earlier, if someone passes within 4 years, you can probate their will or file an application for administration. To probate a will, the judge determines whether the decedent left a will compliant with Texas law. If the decedent did not leave a will, you can file an application for administration. If it's been more than 4 years, you can file an application for probate as muniment of title. This requires a legally valid will. And because it's been more than 4 years, every heir at law, that means everyone entitled to inherit under Texas law, have to agree to probate the will and abide by the terms of that will. Once the judge determines that the will is valid and that you're in compliance by notifying all the heirs, the property is owned by the person named in the will. You have to record the order signed by the judge and the will, and then the property has been transferred to whoever is named in the will. This, a lot of people think, oh, okay, so I don't need to be in such a rush to probate. I had a case where the person passed in the 1980s. She had a will, and she left the will to one of her children. The family didn't know that they had to probate the will. 20 years later, they have an issue with the house and learn that they don't have clear title. We spent years tracking down all of the people entitled to the house because it had been 20 years. A lot of her children had passed, so we had to find her children's children. It was tracking down about 40 people to get them agree to probate the will. So please, if you're in this situation, please probate as soon as possible. Finally, there's a process that probably all of you have heard of called adverse possession. That's a legal principle that allows a person to obtain ownership of a property based on continuous occupation without permission from the legal owner for a specified period of time. There are two critical factors. You cannot have permission to live at that property. You have to be living at the property without permission from anyone. Also, it has to be a pretty long period of time. It ranges, the laws vary depending on the situation, but usually you have to have lived at that house without permission for at least 15 years. One of the most common ways to transfer title if someone didn't probate in a timely fashion is called an affidavit of heirship. This is something you absolutely can do without an attorney. Our website has an article that will walk you through all of the steps for filling out an affidavit of heirship. The affidavit of heirship is a legal document that gives property to the heirs of a deceased person. I use it if the homeowner did not have a will or the person passed, a long time ago. They may have had a will, but they've passed away 30 years ago. It needs to be signed and notarized, like I said with the small estate affidavit, by two people who knew the decedent and their family history. You have to include the full legal description, which is found on the deed. It is really, really critical that you do not use the description on your property tax bill. The legal description on a property tax bill is not the full legal description. You can contact the Harris County clerk or the clerk's office, wherever the property is located of the county where the property is located, and they can help you locate that deed. Once you get the paperwork complete, it needs to be filed in the county where the property is located. There is a filing fee. On Harris County, it's going to be about $40 or $50 to record that affidavit of heirship. Some of the other counties in Texas, it's a little less expensive. A lot of people get confused about what's the difference between a small estate affidavit and affidavit of heirship. You can only use a small estate affidavit to transfer property to a surviving spouse or minor child. If the person passes and they did not, perhaps they were renters, the only thing they had were some bank accounts, you can use a small estate affidavit for that. Affidavit of heirship is the best way to transfer property. When someone has passed away a significant amount of time ago, they didn't have a will, and you can use it to transfer to anyone. It can be, the surviving spouse, it can be their children, it can be nieces and nephews if they didn't have children. And you can use an affidavit of heirship instead of probate if there's nothing else in the estate that needs to be handled. This is where I get to stand up on my soapbox and say, please make sure that you handle this correctly so your heirs don't go through a mess. The transfer on death deed is a simple, inexpensive way for a homeowner to transfer a home or real estate to someone else upon your passing. If you have a transfer on death deed, it does not affect your rights during the lifetime. You still own that house 100%. You can sell that house. You can use it as collateral for a loan. You're still qualified for your property tax exemptions. And the beneficiary has absolutely no right to the home until the owner passes away. The owner also has the right to revoke this deed. They can change beneficiaries or they can cancel the deed entirely. This is important. The deed has to be filed before you pass away in the county where the real property is located. If you do your homework, you have your deed, you have your will, you put it all in a safe spot. That deed is worthless until you file it in the county where the property is located. You do not need an attorney for a transfer on death deed. We have a toolkit at texaslawhelp.org that will walk you through the steps and provide you with the form. Just like I said about the affidavit of heirship, you need to get the full legal description. If you use the description that on your tax bill that says legal description, you're giving them a cloudy title. Another great benefit of the transfer on death deed is that it protects your property from Medicaid estate recovery. Medicaid estate recovery is a program where if someone uses Medicaid to pay, for example, for nursing home care, once that person and their surviving spouse pass away, Medicaid has the right to seek to recoup their expenses by requiring the house to be sold. Medicaid can only do that if you transfer your property through a will. If you transfer your property through a transfer on death deed or a ladybird deed, it goes outside of probate and it protects your property from the Medicaid estate recovery program. That's the end of my presentation. We have a lot of legal resources for you. I mention my website all the time. There's also some local programs that provide representation. Earl Carl Property Preservation at Thurgood Marshall School of Law provides excellent help for preserving heirship property. Lone Star Legal Aid, Houston Volunteer Lawyers are great resources if you cannot afford to have an attorney. The Houston Bar Association has a wonderful free service available to everyone. It's called Legal Line, and you can speak with an attorney for free to get advice. They cannot represent you, but they can give you really good advice. And finally, there's the Houston Lawyer Referral Service. They can give you referrals to attorneys in any area. They're excellent attorneys. The referral service does a good job of making sure these attorneys know what they're doing. Also, you can request a 30-minute consultation for $20. It's one of the best deals around. You can, if you're well organized, you can get a lot of questions asked in 30 minutes. I'm going to stick around. I'll be monitoring the chat. And then after we wrap up the other two presentations, I will, all three of us will be available for questions. Thank you very much for your time. And I'm going to pass it over to Miss Mabel. And Mabel, you need to unmute your computer. Unmute your,
Okay.
there we go.
Now, I imagine you can, there you go. Okay, I'm going to, good afternoon, everyone, once again. I am going to turn over the navigation of my slides to Diana Paredes. I am not in the office right now, so we're kind of doing this mobily on the go, but I'm always happy to provide this presentation to talk about exemptions, especially after Lisa's given that valuable information on inherited property. I guess I should ask the question before I continue. Can you all see me? You can hear me. Can you see me as well? Perhaps not, but you will be able to see the slides once those come up.
We can see the slide, but we can't see you.
Okay, well, you don't need to see me. The slides are the real important message here. So before I begin, I did want to do a quick ad concerning, I know a lot of you, it's that time of year when HCAD is sending out the valuation notices. So I wanted to just let you all know that if you're interested in additional information beyond this presentation about protesting property and about valuations, which is HCAD's responsibility each year, we do hold some additional workshops that we do this time of year called Protesting Your Property Taxes. Several of those, at least 2 of those, will be held here on the Amos format, and we also have several that are, a number of them that will be done in person around the county. So you can find that information out on the way, where those are on the Amos website, as well as the HCAD website. But for today, we're going to be talking about exemptions, and I will go ahead and get started on that. But before I do that, I want to just kind of quickly give a brief explanation on what an appraisal district does, because a lot of people tend to confuse us with a number of other government agencies. We are the appraisal district for Harris County, and why do we have appraisal districts in the first place, and why do you pay property taxes? Well, Texas doesn't have a state income tax, so property taxes pay for a lot of the local services that we benefit from living here in Houston and here in Harris County. It's important also to remember that property tax laws originate with the Texas State Legislature. It is the responsibility of the appraisal district to administer those rules and guidelines, but they are part of the Texas Constitution as well as the Texas Property Tax Code. And again, the property taxes pay for things like schools, your streets, your roads, police, fire department protection, etc. And if we go on to the next slide, we're going to look at as I talked about, some of the responsibilities of the appraisal district. Our primary responsibility is to value and appraise all county property, whether that be agricultural, residential, business, or business personal property. The time that we do that, when citizens receive the information on how HCAD has valued their property, it's going on right now. So some of you may have, in the last several days, received that valuation notice. Others may not, but in most cases, they're going to already be available online at our website if you're interested in going out and checking them out before you receive the mailed valuation. The other important thing that HCAD does is we administer exemptions, and that's primarily what we're here to talk about. We also certify the appraisal rolls, which allows taxing jurisdictions, that's going to be your school, your county, your school district, your county, your city, in some cases your MUD districts, etc., to set their tax rates according to what we have passed on to them as the property value in Harris County. There's a appraisal district in each county in Texas that performs this function, and we, as I mentioned before, we are actually a subunit of the Texas state government. So we'll go on to the next one. The next slide is going to talk about HCAD appraisals. Again, we are certain requirements by law that we have to be at 100% of market value. We are overseen by the state agency, many of you are familiar with the Texas Comptroller's Office. We do this by a process of mass appraisal, and your values are set based on the sales in your area. Here at HCAD, we're the largest appraisal district in the state, of course, and we're actually the third largest in the country, but we're also the largest in the country that does appraisals annually. We serve over 500 taxing jurisdictions in Harris County. Depending on where you live in the county, you pay to usually around 4 or 5. It just sort of depends on where you live, what those taxing jurisdictions are. And if we go to the next, we'll advance to the next slide, please. And just some important dates that are important. Well, important dates for you to remember in terms of why HCAD has to operate on that annual calendar so that taxing jurisdictions can provide that those tax bills to you in the fall. Everything pretty much that we, in terms of how your property is handled, is based on its condition on January the 1st. That is the date of appraisal. Also important to remember that when you receive that valuation notice that you're receiving now, that you provided that you protest if you would like to by a certain deadline. So the protest deadline is usually May 15th, but it is also 30 days. If you receive it later, it's going to be 30 days from the date of your letter. And then the number of things that go on that allow your tax bills to be calculated and mailed in October. The tax office is going to be talking about that in a little bit. And then, of course, if you have not paid them by February the 1st, they go into a delinquent status. And we'll move on to the next slide that just talks about, this is just to show you what you receive in the mail each year. That's the annual appraisal value notice. And there you can see there the appraised value and the market value. The market value is what HCAD determines. The appraised value is what your taxes are calculated on. That appraised value can be different and can be different for a number of reasons. It could be because of the exemptions that are on the property. Important point to remember, those exemptions are based on the qualifications of that individual who lived in that home as their primary residence. We're talking about residential properties here. And so that's important to remember that you may be, because of certain exemptions that were placed on the property prior to you moving in, your appraised value could be less than the market value. So it's important to remember that the appraised value is based on certain exemptions. Now, the number, and that is the number that's used in calculating your bill as it shows on the next slide. Now, the market value is what HCAD determines, and that's the value at which a property would sell to for a willing buyer on the open market. In other words, it's what HCAD has deemed your property is valued at for what you could sell it for. And our primary role is to establish that annual market value. It's important to remember that protests are going to be based on that market value. However, again, just kind of a quickly go over the opportunity to protest. We're offering that series of protest workshops where we can delve further into that process for you. And those are going to be conducted by our actual folks at HCAD who do the appraisals and who do the evaluations, and they'll be able to talk with you in more detail about how that process works and help you decide whether or not you would like to, or you feel like you should protest your value for that year. And now we're going to go into the topic of the day, which is exemptions. And what are they? How they save you money? How does a person get them? They are administered by HCAD. That's our second most important function. So basically what an exemption does is it exempts a portion of your property's value from taxation. That's on your primary residence only. Those are available. You may have heard it in terms of the homestead exemption, the general residence homestead exemption. And an exemption basically is a discount on taxes for that person based on their qualifications. and then those exemptions are then taken off of the account, and that is what is used in taxing in calculating your tax bill, which the tax office will talk about shortly. A couple of exemptions that are most common when it comes to residential property is the general resident homestead exemption. A person may have that. In addition to that, once they turn over 65, there is something called the over 65 exemption. So an individual, once the year that they turn 65, they're eligible to receive that. There is also the disability exemption, similar to the over 65. And then there is the disabled veterans exemption. There are a number of those exemptions, and that's kind of based on their level of disability for veterans. There are other service-related exemptions that may also be attached to the home based on the owner's qualifications. Quickly, the general resident homestead exemption again. You have to own and occupy that home. It's your primary residence. We do require certain documentation for that. That includes proof of ownership. Your name's got to be on the deed. And we also request a copy of your driver's license be sent in when you're applying for that exemption. The address on the driver's license must match that of the property. So some of the biggest exemptions that you get for having that the general resident homestead exemption is $100,000 is taken off the value of your home immediately when it comes to having with the school tax exemption, and that's by state law. Every appraisal district has to do that. Other exemptions that you see are going to be offered by various jurisdictions, such as the city may offer some, the counties, some other special districts offer them as well, and that largely depends on where you live in the county. Let's see if we go to the next one, which is the over 65 exemption. This is an exemption that you get on top of your general resident homestead exemption the year that you turn 65. The disability exemption, which is one that a person can also apply for, that they do not have to be 65, but if they are qualified as disabled by receiving Social Security or disability, they can receive that. They're eligible for that exemption. Now, some people may not receive Social Security, so that wouldn't be proof. They can also apply for that through their physician statement if a physician declares them as disabled. We have a special form on our website for that. Some of the additional benefits of this exemption include the school tax ceiling or the freeze. Your school taxes are going to be frozen the year that you turn 65. You'll never pay more than that unless you make some substantial improvements to the property. And that doesn't mean maintenance. That means if you were to put a tennis court back there, or you're going to add square footage, you add an extra room or two, then that exemption, the value would be reset to reflect that additional value before your freeze would reapply. You also are going to be eligible for something called a tax deferral, and you can pay taxes in installments and penalties with installments without accruing penalties. Additionally, your various jurisdictions, depending on where you live, will offer certain additional benefits or exemptions for that over 65. And let's move on to the next slide, which is the over 55 surviving spouse, which is an important one for people to remember, that if the spouse living in the home and their name was on the deed as well, turned 65 before the other spouse and they were receiving the over 65, should that spouse pass away, the other spouse, as long as the surviving spouse, as long as they are 55 years of age or older, will be able to continue that exemption as long as they're living in the house. And as you can see, the tax deferral still applies, as does the school tax ceiling. If we could go to, someone mentioned we might be a few slides behind. If we can go, I've just finished with the over 55 surviving spouse exemption. And now I'm going to go to one that talks about the heirship exemption, which is a pretty important one for individuals that may be living in heir property. Previously, typically when the owner dies, the previous owner passes away, perhaps they had siblings, perhaps they had children, which they did not leave a will, leaving the home to one specific heir, but the home is left to, say, four kids. Typically, or it has been in the past on the space, that if you live in that home and you're not 100% owner of it, you may not be eligible for 100% of those exemptions. If it's 4 people, you could only be eligible for a 20% exemption. However, if you are living in the home and it is your primary residence, then you would be able to receive that exemption by taking a few extra steps that would include getting your siblings to agree to allow you to receive that, because you are living in the home. You're paying for the appraiser. You're paying for all of the expenses. So we do ask for some additional information when that happens, but as you can see, it's listed here on the slide. I hope that's showing the affidavit of ownership, as well as the death certificate of the prior owner, copy of the most recent utility bill. We need that just to prove that the house is being occupied, and then any citation or court records that you can provide showing your ownership eligibility, if possible. Now, those particular questions and procedures that you need to go through, if you are a little bit confused, please feel free to call our exemptions department at HCAT, and our exemption specialist will be more than happy to walk you through those. Now, if we can go to the next slide, we're going to be talking about the exemptions confirmation card. There were, some of you may have heard recently where people have been worried about the fact that they may have to reapply for their exemptions every 5 years. There's been some confusion about that because the state passed that law during the last legislative session, and it kicked in this year. All of the appraisal districts may have, while I mentioned earlier that they are required to follow state law, they may have different procedures on how they do it. With this particular new law, they may require, some counties may require this to be done in a different way. However, at HCAT, you all may remember receiving, usually in December or early January, you get a little postcard from HCAT. And on that postcard, it lists what the exemptions that are currently on that home. It's important, if nothing's changed, you see that postcard, you just kind of throw it in the drawer. If something has changed, then this postcard is designed to serve as a reminder to the person living in that home. Hey, you may not be eligible for those exemptions that we currently have on file here at HCAT. Here's your opportunity to call us and change that. Also, in addition to that, the postcards, if that person is no longer living in the home, those cannot be forwarded to another address. They come back to HCAT, in which case our staff makes a reasonable attempt to try to contact that owner in other ways. However, if they're unable to contact them, the exemptions you could lose those exemptions and have to reapply. So again, this is been deemed an appropriate method for making sure that we audit exemptions annually. So just keep that in mind. And again, those postcards are mailed typically in early December to early January. One thing I want to make clear before I hand this over to the county: exemptions versus deferrals. There are a lot of we've run across a lot of people who are afraid to apply for the exemptions, especially seniors who are turning over 65, because there's some confusion about whether or not their heirs are going to have to repay that discount that they're getting on their taxes. Please keep in mind those exemptions are a discount because they were eligible for those. They may also, however, have a deferral on their account. The deferral is a postponement, or they've deferred paying their taxes, in which case those could be due and are generally due within a specified time after that person has passed away. So please keep that in mind. When you hear someone, exemptions, they're your discount because you are eligible for them and you earn them. Once that person passes away, whoever moves into that home at that point is no longer eligible for those exemptions. They would have to apply for their own. So do keep that in mind. And quickly, how do you apply for exemptions? Very quickly, we've got paper forms. You can apply online. Most of the forms online are fillable, or you can send it in through email. We do ask that you submit everything at once, not to delay the process. It can take longer if you do, because we'll have to contact you. We've got to give you a certain number of days to answer, and then once again it goes back into the queue for your exemption to be processed. If you have any questions, we do have a how-to video on our website that you can actually listen to as you fill out the form. So that's an important thing to remember. Also, I do hope you can hear me still. Can everybody still hear me?
Yes, we can hear you.
Okay, I'm sorry. The exemptions, so that's how you apply. I want to warn folks, if you're moving into a home or whatever, you may get letters from people saying, oh, we can get you a designation of a homestead. We'll charge you $65 or whatever. If they're asking you, saying that they will apply for your exemptions, please remember that acquiring these exemptions is free to the property owner. You only need to contact HCAD and send in the appropriate information. This is what our website looks like. This next slide, if we'll advance to that one, it's going to show just the landing page on our website. And you can see under that blue bar where you can go in and get a lot of additional information about exemptions, you can actually go out and search, do a property search for your particular residence, making sure which exemptions may still be on there. We do have, it's going to say if the property has a residential homestead exemption, it's going to say that. If it has also an over 65 or a disability, one of those, it's not going to specifically state that it's an over 65 or disability, because that would be telling the public that a disabled person or a senior lived in the home, and that's confidential or personal information we cannot give out on a public website. But it will say multiple, and you know what you've applied for. So again, though, however, if you have any questions, please feel free to give us a call or shoot us an email. And this is our information again in terms of where we are. We're out on the Northwest Freeway. You really don't have to drive all the way out there. If you, for general information, feel free to call, feel free to email. And that is the information that you see on the screen right now. That is my presentation in terms of exemptions and how those work and why they may be really important when it comes to clearing title on property that you're inheriting. I thank you for listening, and I'm now going to turn it over to my colleague over at the tax office. Dave?
Hi, good afternoon, everyone. Glad to be on. Let me go ahead and share my screen. Bear with me just a second. Yes. Great. Can everyone see everything okay?
We cannot see the presentation.
Screen. How about now?
Yes, now it looks
Perfect.
I can see it now.
Wonderful. Okay, well, hello everyone again. My name is Shay Pinkowski, and I'm with the Office of Annette Ramirez with the Harris County Tax Assessor Collector and Voter Registrar's Office. And I'm going to be talking a bit about property taxes today, how we calculate them, what they look like, and then what exemptions can do for you to assist you, along with a couple of options that we have available to the taxpayers of Harris County for paying your property taxes. And I'm available to answer some questions if any questions occur during the presentation. So let's go ahead and get started. Last year, we elected our new tax assessor, collector, and voter registrar, which became Annette Ramirez. She is new to our office. She has 20 years of experience in as a legal advisor, and she is full of a wealth of knowledge. She has plenty of great ideas for our tax office becoming better, and we're super excited to have her. But if you'd like to read up a little bit on her, this is the information that we have in regards to her background. We, as the Harris County Tax Office, collect property taxes for over 80 jurisdictions in Harris County, along with some special taxes and fees. We register vehicles for, transportation purposes, both commercial and personal vehicles, along with title and transfers. We're the office that handles those. And in addition to those, we also maintain the voter registered roll for registered voters in Harris County. So whenever you go to register to vote, that's through our office, and we maintain those records for the next year. The Harris County Tax Office as a whole for property taxes collect over $1.7 million in 1.7 million properties, and that adds up to about $8 billion in property taxes each year. We disperse to the jurisdictions that we collect for, so those 80 plus jurisdictions that we collect for on a yearly basis, we disperse those funds that we collect to those jurisdictions, and that's kind of how that process works. We're the entity that collects those, but we're not necessarily the entity that keeps those funds. All of those get distributed out to Harris County, Houston ISD, City of Houston, along with Harris County Flood Control, some schools, and MUDs, along with a multitude of other special taxes that are collected. So in the past couple of years, we've had some changes to our property taxes. In addition to increasing the exemption amount for our over 65 and disabled homesteaded properties from $229,000 to $250,000 for Harris County residents, or for those Harris County jurisdictions. The City of Houston has an increase for those over 65 and disabled homesteads from $160,000 to $260,000. And the school, as a lot of you saw in your bill last year, increased from $40,000 to $100,000. So on your school ISD bills, you would have seen a pretty big difference versus the years prior, where you saw a greater reduction to your taxes if you have that house on a homestead. We also have it now where we are able to prorate for your property taxes homestead exemption, where instead of having to wait for the first full year in which you occupy a property to have that homestead exemption placed on, you are able to do so from the date in which you move into that property and become owners of it. And HCAT is able to assist you with getting that process started, but it does save you a bit of money in that first year of owning a home, as opposed to having to wait for that first full year in which to have that exemption apply. Now, what you see whenever you receive your bill in the mail is something similar to this. This bottom coupon here in the big picture is what the section of the property tax bill that you would send to us along with a payment. So if you're used to mailing in a check to us in order to pay your property taxes, this is what that portion looks like. The tax bill on top includes the details of your taxes itself, and that part you can keep for your own reference. In addition to being able to find that online should you need a copy of it. But this is what your tax bill will generally look like whenever you're receiving those at the end of the year. And normally that would be around October, November when you start seeing this bill roll around. In addition to receiving your tax bill in the mail, you do have the option of electing to have your tax statement electronically sent to you, it would be sent to you in an email. And in order for you to do so, you'd be able to register on our website and request for that statement to be filed to you electronically as opposed to by mail. Now, do keep in mind, whenever we do send those statements out to you via email as opposed to mail, that electronic tax statement takes the place of your mailed tax statement. So you won't receive one and the other. You can choose between either. And if you make no choice, then you will get yours mailed to you. So how do we calculate your tax bills? So we begin with the taxable value that's provided to us by the Harris Central Appraisal District. They determine what your appraised value is. And then we multiply that value times the tax rate. The tax rate is something that is determined by every jurisdiction individually, meaning that Harris County has a tax rate, Harris County Flood has a tax rate, and they all have their own individual rates that they come to a consensus on a little bit closer to end of the year. And when they come to that consensus, they let us know, they let the appraisal districts know, and then they post it on their own systems websites as well, so that we're all able to see what the tax rates are going to be. As of now, they haven't been determined yet, but later on in the year, we'll start seeing them pop up. But we multiply the taxable value times that rate for every jurisdiction, and then we add those totals up to conclude to your full tax bill. So the tax bill that you'll see multiple itemized lines, which would include all of the jurisdictions that are applicable to your property. And all of those lines would add up to your full property tax bill that you would pay to us. If you have a jurisdiction that is not collected by us, but is collected by, say, another tax assessor collector, say for Pasadena ISD, then you would receive multiple bills. You would receive a bill from us that does not include an ISD, and then you would receive a bill from them, which would include just your ISD. So our bill is a little different because it does have all of those jurisdictions on it. So it does look like a pretty big amount, but it's because of all of those individual jurisdictions that we collect for. This is a visual representation. Whenever you get a homestead exemption, or later on a homestead and an over 65 exemption, your property taxes are reduced greatly by those exemptions. As you can see here, just as an example, a property tax bill on a property of $342,000 could be somewhere in the realm of $7,000. Whereas if you had a homestead on that property, your bill would be somewhere closer to the realm of $5,000. And if you had the homestead and the over 65 exemptions on that property, then your tax bill would be looking more towards about $1,500. So you can see how big of a difference it makes to have those exemptions on your property, and why we recommend so highly that whenever you do become of age or you do become a homeowner of your own home, that you go and apply for these exemptions, because it really does make a very big difference whenever you're looking at your bill as a whole. We have received some pretty bad luck in recent years due to weather, due to freezes, amongst other things. But, you know, as Houstonians, we're pretty frequently used to seeing a lot of hurricanes. But we do have assistance for damaged property in disaster areas. We had the derecho last year, along with the freeze. So property owners can claim a temporary property exemption for the percentage of the property that received damages and sustained damages. The application is available on the appraisal district website. So if that is applicable to you in recent times, you'd be able to apply for it there. We do request that you include any additional documentation, photos, repair estimates, or any other additional information that could give us or give the appraisal district a good idea of what damages were done and what the percentage of that damage includes. It does have to be approved before it can be processed, and that is subject to the timeline that the exemptions are normally approved by. So if that is something that is applicable during that time, you know, feel free to go ahead and take that application to the appraisal district in order to get that set for you. Another thing that we have that helps in reducing how much tax you pay as an over 65 disabled homeowner or disabled veteran is something called a tax ceiling, or you'll constantly hear it being referred to as a tax freeze. What this does is it limits the amount of taxes that you pay for your school taxes, along with some other jurisdictions, but not all property taxes, not not all jurisdictions have something called a tax limitation. This applies to homeowners, as I mentioned before, that are over 65, disabled, or disabled veterans. And it's something that helps reduce how much you pay in your taxes by limiting how much higher that bill can become for that specific jurisdiction. For example, for your schools, if it gets capped at $500, being your tax bill for $500 a year in which you turn 65, then the next year, even if the value of your property and the rates dictate that you pay more than $500, your tax ceiling requires that will be limited to 500. You would not pay more than 500. However, you could, if the tax rates and the taxable value of your property require it to be paying less. So you could always pay less on a tax ceiling, but you could not pay more. And again, this is only by jurisdiction basis. It is not all jurisdictions. It's not all bills. But it is for your school. So if you have the over 65 exemption on there, then you'll have a tax ceiling placed on the account the year that you turned over 65. And that's could be something that causes your bill to be lower than your calculations might dictate. In addition to tax ceilings, we also have, Ms. Mabel discussed earlier, something called a tax deferral. Now, the tax deferral and the exemption for over 65 is very different, but the purpose of that tax deferral is to help you avoid and prevent foreclosure on your home. When you're unable to make those payments, or if you are over the age of 65 or disabled and are on a limited income, the tax deferral is an excellent tool to help you maintain your property in your ownership, avoid foreclosure, but also to help you pay off those property taxes in a time that in which you are capable of doing so. It reduces your penalty to zero, and it causes your interest to go to 5% per year on any unpaid balances, meaning if you're still able to pay your property taxes and you have a deferral on there, but you're capable of making your full tax payment in the due time, you're more than welcome to do so. There's no requirement that you do not pay property taxes, but it is a tool in which if you forget, if you are unable to make that full payment all at once, or if it becomes difficult in which to do so, you have that extended period of time with a reduced interest rate to help you make those payments and stay in your home. The deferral ends upon the change or sale of a property. So should you decide to move out and live in somewhere smaller, or should you unfortunately pass away or pass the property on to heirs instead of yourself, that deferral ends. And that once that deferral ends, you have 181 days to pay the entirety of what is due at that rate for the deferral, after which you would have additional penalty and interest fees for whatever the time in which you did not pay those property taxes would have owed to. You can apply for this through the appraisal district and complete that section there. And you must, as I mentioned before, be either the homestead property of an over 65 person, a disabled homeowner, or disabled veteran. One thing to consider whenever you're thinking of applying for a tax deferral is that if you have a mortgage, if you have a mortgage company, or if you're paying a loan to a bank on your property, that you consult with them first. Not all banks are accepting of a deferral as a non-payment of taxes, and will escrow your home if they believe that the taxes are still requiring to be paid, and if they do not accept that deferral as a method of payment, because in essence those taxes still are required to be paid. And when you have a loan on your property, it becomes that bank's responsibility to pay, and then they collect from yourself as the person who take out that loan or that mortgage. So just keep that in mind. In addition to all of the options that we have available to us for our over 65 and disabled homeowners, for extending the amount of time in which they pay. We also offer payment plans, and these are applicable to anyone. They're not necessarily required to be over 65 or homestead. These are payment schedules that are tools to assist you in paying off your taxes when you require more time, while also allowing you to avoid those collection efforts and foreclosure actions that could occur if taxes remain unpaid. So those can begin as soon as February 1st. And can be anywhere from 12 to 36 months, depending on the payment plan and what is applicable to your account. When you're in a payment agreement, attorney's fees, if they have not already been added to your account, won't be added to the account afterwards, meaning normally those attorney's fees begin to be added on in July. And if you reach out to us prior to those attorney fees being added to your account, we're able to make that payment arrangement for you and help you avoid that additional penalty and interest that would be incurred otherwise. So a bit more detail about those payment plans is here. We have two different types. One is a homestead plan and the other is an other payment plan. Now, homesteaded plans are special because they do get an additional time extended period in which you can create that plan for. You can make it anywhere from 12 to 36 months, and it applies to all homestead residences. So even if you are over 65, if you'd prefer to do it on a payment plan, you're able to do so, but you're not required to be, as with other options. It's a 1% interest per month in addition to your initial penalty that would be collected in that month. So in February, that would be 7%, followed by 9, 11, and so on and so forth. You can include current and prior taxes, meaning it would be for, in this case, 2024. If you have prior year's taxes that are still owing, you're able to have all of them applied to the same payment arrangement as of this time, and be able to make your efforts to make those payments and prepare for next year's taxes, which will be the 2025 tax year, in order to be ahead of the curve and be able to make those payments timely. Other payment plans that are not homesteaded payment plans are our non-residences, our business, personal property, and commercial property. These are all taxes that are able to be put on a payment plan. However, the extent that we're able to offer for those is 12 months, and you do pay for all the accrued penalty and interest fees on those accounts. However, what the difference is again, as I mentioned before, you avoid collection efforts so long as you are able to create that payment plan prior to those collection fees being applied to the account. All payment plans must be paid monthly, and you pay at the end, before the end of each month. So you can pay at the beginning of the month, the middle, the end. It's up to your preference, but so long as the payment is received and paid here to the office prior to the end of the month, it would be counted as a successful payment. And then, of course, you wouldn't need to worry about it being discontinued. In addition to all other options that we have, you do have, if you're over the age of 65, homestead, or homestead disabled homeowner, or homestead disabled veteran, or their surviving spouse. We offer something called a quarterly payment plan. When your account is set up to have those exemptions on it, you are able to have your payment plan created to make those payments once every other month, essentially. The first payment would still be due in January, but you would split your whole payment, your whole tax levy into 4. And your first payment would be due in January, with your second payment due at the end of March, your third due at the end of May, and your fourth due at the end of July. Those are 4 equal payments that would assist in being able to give you some additional time to make those payments complete, and hopefully alleviate some of the strain of having to continue to make those payments timely, is all at the beginning of January. But that's what the purpose of this quarterly payment plan is for. You do have to be approved for that exemption before those payment plans can take effect. But if you contact our office, we will be able to check that for you and check the status, along with being able to assist you in setting up that quarterly payment plan should the need arise. We do have separate payment options available to you. You can pay online, by mail, over the phone, or in person. And I have all of the contact information here if you would like to take that down. We do recommend, or at least want to let you know, that payments online and by phone if you pay with a card, whether that be a debit or a credit card at any point in time, you are paying an addition, or you would pay an additional 2.5% fee on the total amount that you are paying to our office. This is not a collective effort for us. This is a collective effort from the cardholder and your bank. And it is required that it be paid by the consumer. So, just a heads up, if you would like to avoid that fee but would still like to pay online, you can pay by something called an e-check. It's an electronic check option that we have. And essentially, instead of using your card information, you would input your account information from your bank and be able to pay very easily the same way as before on our website by selecting e-check, and there is no additional fee for paying with an e-check. So keep that in mind for those of you who have bills who would not like to pay that 2.45% fee. Alternatively, you can go into an office or mail in a check. Or if you prefer to pay in cash, all of our branch offices are able to take cash payments as well. And that is something that you are able to do at any of our branch offices. We are here to help. We have representatives who are able to take calls, receive emails, along with checking mail and fax machines. But if you have questions, if you're unsure of something, or if you're in the process of paying your taxes and aren't really understanding why taxes look the way that they do, please feel free to call us. We're happy to help. But that is it from my end. I'll keep the information up here for a little bit longer. But did Miss Lisa want to close us out today?
Yes, I want to thank all of you for coming today, and thank you for your patience with our technical issues. I apologize for that. As many years as we've been doing Zoom now, it seems like we still run into issues now and then. I will check the chat. I didn't notice very many questions, but if any of you either want to put a question in chat or you can raise your hand in Zoom, we'd be glad to answer them. Okay, I have one. And this is from a Sammy Hughes. I have an affidavit on file with the county clerk for my property, but not a title of deed. Do I need to get a title of deed? First of all, a title and a deed are two different things. Title is just the legal right to the property. A deed is the piece of paper saying that you own that property. If you have an affidavit, I'm assuming you mean an affidavit of heirship. That's all you need. You don't need a deed in that case. Your affidavit of heirship is sufficient proof of ownership. And I also want to let you know that next Tuesday we have the evictions Know Your Right presentation. And I'm just going to double check our schedule here because I know there's a couple of great events coming up. We are also going to be in person at the A-Leaf Community Center, which is a great event. We always love seeing people out in the public, and A-Leaf has a beautiful community center. So we would love it if you came out. Okay, so we've got next week, Evictions Know Your Right on the 15th, and then Maintaining and Adding Value to Your Home on the 16th. And then there's quite a lot of property tax issues coming up as it is the season for protesting. So on the 23rd, you're going to have property tax protests. And I'll leave it up for about 10 more minutes to see if anybody has questions. We will have coffee and conversation in person at the A-Leaf Multi-Service Center. It's at 11903 Bel Air. We'll be there from 10 to noon, and it's a really fun event at a beautiful location. You can meet us in person, ask questions to us directly. I know that Lone Star Legal Aid will be there, and they can do intakes to see if they can help you with any of your cases.
Hi, Lisa. Good afternoon. This is Sarah. I have a question from you.
Sure.
Thank you very much for a very informative session.
You're welcome. Thank you.
Okay, my question is, I have a business in Harris County, and the law firms, they protest for the the value of the business, and accordingly, the taxes being filed on the value, which is finally protested. My question is, I have seen the law firm did a good job, but the I would say the title which is written um, on the business on HCAT side is, for example, I say it's a car wash, right? So it is basically a full service car wash, but there it is written like a specialized car wash, and then the price with the car washes around it was not comparable. It's much more than those. I do not know how do I get that thing changed because that is probably not right there.
That is a question for people from HCAD, or I don't know if Shay from the tax office knows, but if Lydia
Okay.
could take this call, or Shay, if you could, because she's asking about the valuation of her business.
So I can
Yeah.
assist a little bit in general terms.
Mhm.
However, I believe HCAD would probably be the better option for this. But as far as the valuation of your business, are you referring to stating that the valuation that they're giving you is incorrect? Are you stating that
Actually,
just
the valuation, if I compare it with the businesses around that business, the same, comparable, it is much higher than those. So
so
probably this is one of
business?
the reasons. Yeah, sorry, go ahead.
Oh no, I'm sorry. So business personal property and property itself are very
Yeah.
different, in which you don't necessarily judge the amount that the valuation of the property taxes would be for a business in the same way that you would for a property. It's not all going to be the same because you're in the same area. Business personal property is based off of the amount of machinery and equipment, computers, furniture, and fixtures that you have for the business that are making you this money in the thought of property tax. That's what determines how much the value of your property taxes of the property is for
Yeah,
business personal property.
Mhm. Yes, I'm
Um,
talking about the property tax, not the business personal property.
okay, so then that's definitely more of an appraisal district question.
Okay.
But it could do anything with are you looking at the appraisal value, or are you looking at the tax amount that you're paying?
No, I'm talking about the appraisal value, because that is higher than the other businesses, compatible businesses around it. Why I'm saying that, because I have another business which the tax value of that business is much lower compatible to the other businesses around it. But when I looked at very carefully, I saw that there is something written like, for example, I'm just giving you an example, like a full service car wash and a specialized full service car wash, but both the businesses doesn't have anything different. They are same. So maybe I thought that is one of the reason that the valuation is too high. Um, I just wanted to know someone to whom should I contact and ask that, is this the reason, or
So if you believe that it's being unfairly high on the
Mhm.
values, it is something you would want to go and protest with the appraisal district. You would want to bring in that information, bring in the copies of other properties of similar nature to yours in nearby areas, and bring them in for your protest so that they can see what the differences are, and hopefully be able to assist you with that. But you would need to
Okay.
file that protest with the appraisal district.
Okay, if there's a law firm which is already doing that, can I do it at myself too, or I need to revoke their authority first?
That would be something that you would need to request from the appraisal district. As far as I know, if they're already in the process of
Mhm.
protesting that value, I wouldn't say to do it again if you're already in the middle of one. I believe you can only do it once per property, but um, I might be able to get an answer from Mabel here in a minute if she's able to type it in at some point. But yeah, normally you can only protest the property once. So if they are currently doing it, then I would imagine that they would continue to do so. Um, is
Okay.
it something that you would like to discuss maybe with them if they're already in the process of getting that protest for you?
Okay, I think this is the time to, they're probably already in the process. I think I should reach out to them and tell them, because they were the ones who did it last year, and I wasn't able to apprise them with this situation. Okay, thank you very much. I will talk to them.
Not a problem.
Thank you so much, Shay.
I have a
And
question.
yes, she's right. It is, you do have to revoke them as your agency, according to Miss Mabel. And you can use that agency removal form from the appraisal district website to submit it into them directly.
Okay,
Sorry,
thank you.
not trying to
Thank you.
interrupt.
No, no. Thank you so much.
Any other questions?
Someone before I rudely interrupted.
Yeah, I thought that someone said they had a question. If they want to try one more time. We were still wrapping up that other question.
I do. I'm Sammy Hughes.
Oh,
I
the
have
Hughes
I
thing.
have I have a question for you, Lisa. I have an affidavit for my property, but no deed. Do I need to get a deed?
Is this an affidavit of heirship?
Yes.
You do not need a deed. The affidavit is sufficient. Well, let me backtrack. Affidavit is sufficient to show that you have title to that property. Now, did
Okay.
did the affidavit leave the property to you, or do you share it with other family members?
No, it's to me.
Then you're good. The affidavit is all you need.
So I don't need to get a deed.
No, ma'am. The
All
affidavit
right.
is sufficient proof. Now, I
All
would
right.
highly recommend it, if you want to leave the property to someone else, that you use a transfer on death deed. But
I got that.
okay, you are in great shape then.
All right. Thank you.
Thanks for your question. Well, it looks like this is all we've got. So I want to thank everybody for coming today. We had a great crowd and we always appreciate your questions. We're here the second Thursday of every month, and every month is different because we get so many different questions. And we hope to see you at our other events at all. Thank you so much and have a great afternoon.
Alrighty, thank you everyone. Have a great day.
Thank you so much. Have a great day too. Bye-bye.
Thank you for coming. Bye-bye.
Bye-bye.